Judiciary, Civil, and Criminal Jurisprudence will come to order. Madam Secretary, please call the roll.
Senator Luetkemeyer.
Here.
Schroer.
Here.
Coleman. Here. May. Roberts.
Here.
Thompson Rader.
Okay, we do have
And Trent. Sorry.
we last but not least, we do have a quorum. I would now make a motion that we go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are now in executive session. We now make a motion to bring before the committee for its consideration Senate Bill 1070. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is in front of the committee. For the benefit of the committee, this is Senator McCreery's bill that she presented on last time that creates the cyber stalking task force. There is a very modest committee substitute that she has asked for the committee to adopt that basically says rather than OSCA making the appointments, it would actually be somebody on behalf of the state Supreme Court. I don't have any issues with it. But is there any further discussion before I make a motion to adopt the Senate committee substitute? Seeing none, I would now make a motion to adopt the Senate committee substitute. I have a second. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You've adopted the Senate committee substitute for Senate Bill 1070. I now make a motion that we vote do pass Senate committee substitute for Senate Bill 1070. A second. It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call roll.
Senator Luetkemeyer.
Aye.
Schroer.
Aye.
Coleman. Aye. May. Roberts.
Aye.
Thompson Rader. Trent.
By your vote of 6-0, you have voted do pass Senate committee substitute for Senate Bill 1070. I now make a motion to bring before the committee Senate Bill 1200. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. The bill is before the committee. This is Senator Trent's bill from last time. I understand there is no committee substitute or, okay. This creates the DWI diversion program. This is something that was voted out of the committee last session. With that, I'm going to kick it over to Senator Trent to see if he.
So we didn't actually.
All right. We're going to hold on Senate Bill 1200 for the moment, Senator Trent's request. So that said, I would now make a motion to bring before the committee Senate Bill 1266. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. The bill is before the committee. This was my bill that I presented on last time that simply adds prosecuting and circuit attorneys to the list of individuals who can request money from the Witness Protection Fund. It had some other provisions in there that relate to administrative rulemaking. We do have a Senate committee sub that has been distributed to the members. It simply strips back all the provisions that deal with administrative rulemaking and just leaves in place the provision that allows prosecuting and circuit attorneys to request money from the fund. So that is all the Senate committee sub does. Before I make a motion to adopt the Senate committee substitute, though, is there any discussion? Seeing none, I would make a motion to adopt the Senate committee substitute. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You have adopted the Senate committee substitute. I would now make a motion that we do pass Senate committee substitute for Senate Bill 1266. Do you have a second? It's been moved and seconded. Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer.
Aye.
Coleman. Aye. May. Roberts.
Aye.
Thompson Rader. Trent.
By your vote of 6-0, you have voted do pass Senate committee substitute for Senate Bill 1266. As I mentioned last time, this was noticed up as a consent bill. So I now make a motion that the committee vote the bill out consent. It's been moved and seconded. All those in favor signify by saying, oh, Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer.
Aye.
Coleman. May. Roberts.
Aye.
Thompson Raider. Trent.
By your vote of 6-0, you have voted do pass consent. Senate Committee Substitute for Senate Bill 1266. And now make a motion that we exit executive session. It's been moved and seconded. All those in favor signify by saying aye. Aye. We're out of executive session. First up is Senate Bill 1096. Senator Roberts, whenever you're ready.
Good morning, Senators. I'm Senator Steve Roberts from Missouri's 5th District. Thank you so much for allowing me to present Senate Bill 1096. This is a similar bill identical to Senate Bill 215 from last year, which passed this committee unanimously, and it codifies a framework for the alternative dispute resolution process. As an attorney, alternative dispute resolution is critical to the efficient practice of law and keeping issues out of the courts, which can be solved without their involvement. Much of this framework reflects existing norms of the legal community and provides individuals a new process with a better guide than what exists currently. If you have any questions, I'd be glad to answer them, and we have some experts here as well.
Great. Any questions for Senator Roberts? Seeing none. First witness in support of Senate Bill 1096.
I'm not sure where that goes, but Mr. Chairman, members of the committee, my name is Paul Ladahoff. I'm part of the Center for the Study of Dispute Resolution at the University of Missouri School of Law. I'm also a board member of the Association of Missouri Mediators, but today I'm here in my capacity as co-chair of the Missouri Bar ADR Committee. I wanted to, in addition to add on to what Senator Roberts said, just give you a real brief procedural kind of history of where this idea has come from, and a little bit more, or be willing to answer questions about the bill. So back in 1986, revised statute 435-014 was added. It was primarily an arbitration statute. Mediation was kind of new and unknown at that time. It's developed since to be the very important aspect of litigation. And with that growth has come a need to clarify, refine that. So back in 2010, the Supreme Court put together a Rule 17 commission, ADR commission, to look at their Rule 17, which was based on 435. And they came out with, after a lot of input from folks on the committee and outside, some recommendations, but it was apparent that it was more appropriate to include in a statute, to revise the statute rather than just to adjust the rule. So that's where our ADR committee took it up. We spent time with attorneys, members of our committee, mediators, mediation organizations, and end users, the folks with disputes, to think about how to move this into a revision of 435-014. So the proposed rule changes things by adding definitions, by clarifying both confidentiality and some important exceptions to confidentiality, talking about things like conflict of interest and impartiality, making sure that it's clear that it doesn't impact parties' due process rights, but also that courts explicitly have the ability to refer cases to mediation, and what kind of procedures would happen when that happens. So we think this is helpful, important, and it's been a long time in the percolating, kind of refining, discussing aspect, and we're grateful to the chance to talk about it today. So I'd be open to any questions that you may have.
Thank you for your testimony. Any questions for the witness? Seeing none. Thank you for testimony. Further witnesses in support of Senate Bill 1096.
My name is Andy Briscoe. I'm the registered lobbyist for the Missouri Bar, and we'd just like to go on record as supporting this.
Thank you for your testimony. Any questions for the witness? Senator Coleman.
I'm so sorry you've drawn the short straw. I meant to ask the senator earlier, but I presume, is this identical line? I haven't had a chance to do a line-by-line comparison between this year's and last.
I believe it is.
Okay, thank you so much.
Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 1096? Seeing none, any witnesses in opposition to Senate Bill 1096? Seeing none, any witnesses for informational purposes only? Seeing none, Senator, any concluding remarks?
No, thank you.
That will conclude the hearing on Senate Bill 1096. Next up, Senate Bill 1221. Senator Trent, whenever you are ready.
Thank you, Mr. Chairman, members of the committee. Curtis Trent, representing District 20. I think we have a long hearing today, and I don't think all these witnesses are here for me. So going to attempt to make this as brief as possible because I think we do have a couple of witnesses here that would like to testify on this bill. But this is basically uniform electronic wills and electronic estate planning documents. There's a section in here that specifically deals with estate planning during COVID, and I think COVID kind of revealed the degree to which that some of these things that have traditionally always been done in person are going to increasingly be done electronically going forward. And so we want to have uniform policy in place that facilitates the orderly use of electronic digital means to engage in estate planning. So I'd be happy to answer any specific questions the committee has. Otherwise, would love to hear from our star witnesses.
Any questions for the bill sponsor? Seeing none. First witness in support of Senate Bill 1221.
Mr. Chairman, members of the committee, my name is John Chalice. I'm a partner at the law firm of Kirkland Woods and Martinson in St. Louis. Thank you for your time today and allowing me to testify on Senate Bill 1221, and thank you to Senator Trent for bringing this bill. In addition to being a practicing attorney, I am also honored to serve as the current chair of the Probate and Trust Division of the Missouri Bar. As the bill is currently laid out, it is broken essentially into three separate proposals. So the first part of the proposal is on pages 1 and 2 of the bill. This is a minor modification to Section 108 of the Trust Code, and it deals with a situation where the trustee wishes to change the principal place of administration of a trust. The legislation does nothing to change that, but under currently existing law, if the trustee desires to change the principal place of administration, they are required to send a particular notice to the beneficiaries. This change in the law would add just one sentence that the trustee has to include in that notice, which is that a change to the principal place of administration may affect the beneficiary's rights. There are a number of states outside of Missouri that are going to very strong kind of silent trust type provisions. And so we felt it was incumbent before a trust got moved out of Missouri for the beneficiaries to at least know that if it goes to one of those states, that may negatively impact their rights as a beneficiary. So that is the first part of the proposal. The second part of the proposal that Senator Trent talked about begins at the bottom of page 2 and goes through page 10. And this is referred to as the Missouri Electronic Wills and Estate Planning Documents Act. This act, similar to the prior change, came through the Probate and Trust Division of the Missouri Bar. The goal, when we put together the task force to draft this legislation 3 years ago, was to take what the Uniform Law Commission had done at that point with the Uniform Electronic Wills Act and essentially incorporate it into existing Missouri law. So to be clear, this act, if passed, would not require any changes to how estate planning documents are currently drafted, but it does provide a new option for estate planning documents to be done in electronic format. In putting together this legislation, we tried not to change any of the fundamental provisions of Missouri law, so a will still has to be signed and witnessed. It has to be in writing, can't be a will by TikTok or anything like that. We did not adopt the harmless error standard that a number of other states have, but Missouri has consciously chosen not to adopt on numerous occasions. We also chose not to adopt a new notarization structure Rather, we use the Remote Online Notarization Act that was passed through this chamber a couple of years ago. 14 states currently allow some form of electronic wills. A lot of those do not have the same stringent requirements that Missouri does around estate planning documents. And so one of the reasons why we believe that it's incumbent to try to move this bill forward is, believe it or not, as someone sits here today, they could be doing an electronic will that would be governed by Nevada law, because Nevada does not require physical presence in the state in order to be able to do an electronic will in Nevada. And I'm not picking on Nevada, they're just one example, but and their laws are not as stringent or consistent with what we've always had here in Missouri. So without procedures for how we would deal with those types of foreign electronic wills, we're kind of in a little bit of a gray area right now. So that's one of the reasons that we want to go forward with this if we can. The other part that we did was the Uniform Electronic Wills Act only dealt with wills. We thought it was important to incorporate all of the traditional estate planning documents as part of that, so trust, powers of attorney, HIPAA authorizations, things like that, and allow those to be done electronically as well. Now, interestingly, after the Uniform Law Commission passed the Uniform Electronic Wills Act, and then we started doing our work, they have now put forward a new uniform law called the Uniform Electronic Estate Planning Documents Act, and they kind of actually pulled from a lot of the work that we did to incorporate other estate planning documents into the Electronic Wills Act. So as Senator Trent said, this development really started during COVID. It has been presented, I believe, before to both this committee and in the House as well. So the final provision begins on page 10. As Senator Trent said, this is really kind of a cleanup provision. There is some question. During the pandemic, the governor issued a number of executive orders. One of those executive orders purported to take away the requirement that the two witnesses to a will be in the same physical presence as the person signing the will, which made perfect sense during the pandemic. But there is some question, and since my practice is in trust and estate litigation, I can certainly envision that whether the governor actually has the authority to alter the statute of wills. So essentially, this is a provision that says that any documents that were done under that executive order, if there is a form document that is done by the attorney that says, yes, everything was done consistently, then all of those documents would not have to be redone, and there's not going to be any question or litigation over those in the future. So with that, I'm happy to answer any questions.
Any questions for the witness? Seeing none, thank you for your testimony.
Thank you, Senator.
Further witnesses in support of Senate Bill 1221.
Mr. Chairman, members of the committee, I'm still Andy Briscoe, registered lobbyist for the Missouri Bar. I'd like to thank Senator Trent for bringing this bill forward that carries a lot of the bar priority pieces of legislation in it.
Andy, you're nailing it on the testimony today. Brief, very brief. The committee appreciates it. Any questions for Andy? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 1221.
Mr. Chairman, Senators David Clarich today appearing in favor of 1221 on behalf of Riesman-Berger. I dropped by House Bill 1886 by your office earlier today, Mr. Chairman, and spoke with Senator Trent about 456-950, a provision that was added to a similar bill currently pending on the House Perfection Calendar in the form of House Bill 1886. Should be probably perfected and third read in the next week or two in your hands. The legislation I had encouraged you to add to this was actually filed in the form of Senator Coleman's legislation, Senate Bill 988, relating to the qualified spousal trust. It is a modification of the existing law. Actually, I think it's more of a clarification of the existing law with respect to permitting the creditor protection, clarifying that there's creditor protection after the first to die in a qualified spousal trust. This is either going to get your absolute enthusiastic endorsement or a moderate enthusiastic endorsement because it's a great idea and it's a wonderful estate planning tool. It's been in existence. We originally sought it in 2010. It was truly agreed to and finally passed, signed into law in 2011. It is an outstanding document. It's something that the Missouri Bar, my law firm, have been working on for a very long time. And I'd like to thank Senator Coleman, you, Senator Trent, and Senator Luetkemeyer for assisting us in this effort. Any questions?
Any questions for David? Senator Coleman?
Mr. Clerch, if you're free for any other hearing on any other bill that you see my bill could be used as a vehicle for, I'd invite you to continue to provide such robust testimony.
Senator Coleman,
Thank you
I'm
for
here
your support.
you. So, absolutely.
Any further questions or soliloquies with the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chairman, members of the committee, David Kent, registered lobbyist for the Missouri Bankers Association. I'm certainly not an expert in electronic wills and trusts, but our general counsel has reviewed this. He likes the new language. We would like to go on record in support of the bill. I believe we also like the QST language as well. So,
any questions for David? Seeing none, thank you for your
Thank you.
testimony. Further witnesses in support, Senate Bill 1221. Seeing none, any witnesses for in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, that'll conclude the hearing on Senate Bill 1221. Next up, Senate Bill 984, Senator Schroer, whenever you are ready.
Thank you, Mr. Chair, members of the committee. For the record, Senator Schroer, 2nd District, St. Charles County, presenting the ICCA Senate Bill 984. Before I start, I'm going to have to, once I wrap up here, if it's okay with you, I'm going to present another bill over there, and then I'll return to answer any questions of any members that weren't here. Back in 2018 and 2022, Missouri voters approved 2 strict regulatory schemes on medical and adult use for THC. Some of these are the most highly regulated in the entire United States when it involves THC products. What the ICCA is designed to do is take any product that has an intoxicating cannabinoid and places it within that voter-approved framework for THC products. The intent of the voters was very clear. If you have a THC product in the state of Missouri, it must be safe, must be untainted from chemicals and other products like pesticides, heavy metals, kept out of the hands of children, and actually reflect to the consumer what the potency is. Study after study, which I have here today, actually reflects that some of these products, these Delta 8 products that are in gas stations being sold to kids, have harmful chemicals, pesticides, and other unknown substances. These products actually got guidance from the FDA, which showed that this was not their intent with the Farm Bill to allow these types of products to be sold to children. You'll hear that Missouri needs a totally separate but entirely duplicative framework to handle these products, and I think this is unnecessary and duplicative under the certain circumstances of this legislation. It is a unnecessary and duplicative expansion of government, which is another attempt to, in my opinion, kill this bill in this heavily red state and keep these unregulated, unsafe products available to kids. There's zero reason why these THC products should not be treated like any other THC product in our state. Similar to alcohol, one regulatory body covers all intoxicating liquors and alcohol, such as beer, bourbon, wine, moonshine, brandy, and even hooch. So with that, I would open it up to any questions. I know that this is a controversial issue given the products, but it is our intent to treat these intoxicating cannabinoids like every other intoxicating cannabinoid that the voters approved in 2018 and 2022.
Any questions for Senator Schroer? Seeing none. So I do understand that the testimony in here may be a little more robust than the last 2 bills, given the number of folks that we have here. We are on a timeline, so I have talked to various folks who I know have interests on both sides of this legislation, and what our ask is going to be is that we're going to have a principal witness who's going to testify first for and then against. That witness will be given 5 minutes to testify. Subsequent witnesses will be given 2 minutes to testify. I would emphasize that we do not want any duplicative testimony. It is perfectly acceptable to come up and to say, I'm representing this organization. We agree with everything that was said by another witness, and to have that reflected. If there are additional documents, materials that you would like the committee to consider offline, if you could please submit those, make us aware, then my chief of staff will make sure that those are circulated to the other members of the committee for their consideration before we vote on the legislation. With that, the first principal witness in support of Senate Bill 984.
Thank you, Mr. Chairman, members of the committee. I think I'm the first contestant. My name is Chris Lindsay. I'm here with an organization called ATTACH, or the American Trade Association for Cannabis and Hemp. I have been lobbying members of Congress related to the Farm Bill. I have been in many states around the country as they are working through exactly the same issues that you are considering here today. And just a few things to set the table here for the discussion. The first is that we are talking about an intoxicant. It's virtually identical to what you would get in marijuana. So this isn't marijuana light. It's the same thing. For a person who is a regular marijuana consumer, they would be right at home taking these kinds of products. And so the net of it is, we think it's appropriate that they be regulated in exactly the same way that the state has adopted for its regulatory system for marijuana, for all those reasons. I also want to point out that these products often sort of get lumped in with hemp. They get called things like industrial hemp and all that, and that sort of gives it a halo as if it's in a special class. And what they're doing is they'll take a molecule that's produced in the hemp plant and they'll put it through a chemical process to turn it into what you would naturally find in the marijuana plant. And once they've done that conversion, it's not hemp anymore. This would be like me coming in here and saying, this isn't vodka, this is wheat. It should be regulated like wheat. Well, we all understand the difference, that a product that's there to be intoxicating needs to be regulated on those terms. So what happened to get us to this point was Congress started working on the Farm Bill in 2014. It's a bill that comes up every 5 years, does everything related to agriculture, most that happens with agriculture. And there was interest in developing a new crop for farmers. They recognized that this used to be a massive crop in the United States. It produced fiber and feed. And so members of Congress thought, you know what, we can do this. And so they created a definition for hemp. Before that time, everything that was this plant was illegal. It was marijuana. It's called the cannabis sativa L plant. And what Congress said was, you know what, we can figure out a way to define these plants that only have trace amounts of the intoxicants, and that's what we're going to set aside for farmers. And that's what they did. So we got this definition. Well, chemists pretty quickly figured out that they could take what naturally appears in the hemp plant and do this conversion to sort of back into the same kinds of intoxicants that you get from marijuana. And this was absolutely not what Congress set out to do. If you talk to any of the members that were involved at that time, they went to extra steps in the record to say, we are not legalizing marijuana. And yet that's exactly what happened sort of in the test tube. And so today we are working, my organization is working with members of Congress, not to change the law, because in their mind they didn't open the door. They just are out to clarify that this was never their intent. States are not preempted. They can create regulatory programs like they do for marijuana, and that's the discussion that's happening. And at the same time, states are all trying to figure out what to do. Some have set up regulatory programs, some have banned. We don't recommend that you ban this because that's a great way to lose control over the marketplace unless you're prepared to put huge dollars into law enforcement, and most states don't have that kind of money sitting around. Now, there are courts that have been brought into the discussion. So sometimes you'll see folks that are sort of the hemp intoxicants folks go into court and say, hey, Congress legalized us. There is a case very early called AK Futures where the court bought into that argument, but we've seen repeated cases since then when courts have not gone that direction. Even in the same circuit, they've said, we don't buy that. This is a different topic. We're talking about an intoxicant. We're not talking about plants in the field. Now, we do believe that these products should be regulated. And some states have banned it. We think that's a bad idea. We think that they do belong into a framework so that there's a better understanding of how to actually respond. This involves things like testing, it's labeling, it's making sure that consumers understand what this is, so the warnings that need to be out there for the public when they come across these products. Folks will buy a product off the shelf that says hemp on it and then be surprised when they end up high after consuming it. And we think that there need to be some sideboards on that, and you get that by having a regulatory system. And then I would just finally say, is my final point here is, avoid the temptation to create a completely separate system, because what will sometimes happen is they'll say, well, this isn't that dirty marijuana stuff, this is low THC hemp, and that belongs where the farming happens, and so put it under the Department of Agriculture. But the problem with that is that the Department of Agriculture often isn't really thinking about consumer products, and they're certainly not regulating intoxicants. You don't have the Department of Agriculture regulating your alcohol industry, for instance. And so we think it really belongs where the intoxicants are being regulated for all the same reasons the voters in this state put it there in the first place, and we think that's a good fit going forward.
Thank you. Any questions for the witness? Senator Coleman.
I have just a couple. Because you work nationally, one of the concerns that we hear over and over again in this body, in particular about advocating, frankly, for reforming the process with which we change our Constitution, is the marijuana legislation that was passed at the ballot box, that the system that we have created is clunky, that it's administratively difficult, and there's a concern that adding additional product to an existing framework that is poorly done would further hinder a bad system. You've seen these systems built across the country. Do you share those concerns about adding product and frankly, volume into an already stressed system that was poorly designed?
Well, I absolutely understand the concern that you've raised, and I think that there has been a tendency for lawmakers in a certain way to sort of overcompensate for the fact that marijuana has been illegal for years, and so they pile on the regulations for the program as it launches. But I think it's a far worse solution to then just say, well, we're going to leave that broken system untouched, if it is broken, and create a whole different one that operates in parallel, because you're going to duplicate all your costs. They still have to figure out a lot of the same lessons. They have to deal with licenses and testing and labeling requirements. All those pieces are there. Now you're just going to do it in two different branches.
So you're not commenting on our system compared to the others, it sounds like. Is that right? I just was, because you see them all, I thought it'd be interesting to hear what your opinion was. Okay, the second question is there testing existing right now to be able to do what you're purporting to do? It seems to me like, and I'm sorry, I've had people explain this to me a lot. I mean, I took honors chemistry 25 years ago, and I squeaked out an A somehow magically. But I don't exactly understand this. What are the testing compartments, and is this something that's identifiable so that we can determine what is just hemp, what a D something 8, I don't know, I don't use any of these products, or THC or whatever. How are those able to be identified within a laboratory system?
So there are two things you're looking for when you're testing. One is
let me ask that differently. Does the system that we have built have the capacity to do the appropriate testing?
It does. And it's because we're, at the end of the day, whether it comes through a conversion process or it grows naturally in the plant, you're looking for a lot of the same markers. The primary intoxicant in marijuana is called delta-9 THC. And delta-9 and other forms of THC, that's the coin of the realm when you're talking about marijuana intoxication. And that's what you're going to look for in a hemp-derived product versus a marijuana. So you're looking for a lot of the same chemicals. You're also looking for a lot of the same contaminants, which is the other part of this, is what
Okay,
else
so hold
might
on, I'm
be-
just going to interrupt real quick in the sake of time. So if we have testing available right now and it is substantively the same as the existing product on the shelf, why would it not automatically be falling under the existing regulations that
Well-
are regulating a specific substance?
That's my understanding. What this bill does is it just clearly says, and sorry about the parlance, if it walks like a duck and talks like a duck, we're going to regulate it like a duck. But there's this sort of feeling that, oh, well, this is hemp and it's different in some way, and so it doesn't automatically fall into the same regulatory system.
Okay, I appreciate it. Thank you so much.
Any further questions for the witness? Seeing none, thank you for your testimony.
Thank you.
First witness in opposition.
Squeezing in here. Sorry. Hey, I'm Vince Sanders. I'm the founder of CBD American Shaman. We're a 9-year-old hemp company based in Kansas City, Missouri. I'm a lifelong resident. I'm wearing my Patrick Mahomes socks this morning for the obvious reasons. What we're here to do is, I guess, discuss of the Farm Bill and how it all started. Previous speaker kind of went over that. I was one of the people that helped form that bill. Did a lot of lobbying in Washington, D.C., one of the founders of the Hemp Roundtable. Although some of these hemp products weren't on the horizon at that point in time, they have become a huge part of the hemp business. Tens of thousands of retailers sell these products all over the nation. We operate in about 37 states, several hundred retail stores. This is easily governed, with proper packaging, 21 plus. We do the same testing as in marijuana. We do heavy metals, and our chemist is here to speak later that can go over all the testing we do, microbial and HPLC testing of the cannabinoids percentages. To take this away retail-wise in the state of Missouri would affect thousands of retailers, not just our stores. You have a lot of convenience stores, liquor stores that are selling these products, that it would cost literally millions of dollars and thousands of jobs, that a lot of people have become dependent on it for a living to pay their overhead. This is not a substance that needs to be regulated by the marijuana industry. That, as you had said, it's a very clunky system. They're struggling to govern what they have. To load more on their plate would be nearly impossible, I think. So if you really want the marijuana industry to thrive, I definitely think you wouldn't put it on there either. I think it's a bad idea either way. And I don't think, that it's the marijuana industry's job to take jobs away from small enterprises. That many people here in this room will talk later. We are a larger company. It would certainly hurt us. We'd be talking millions of dollars a year, probably 100 jobs in the Kansas City area that we use to manufacture these products. We'd have to either leave the state or discontinue it, probably just move across the state line to Kansas in our case because we're right there, and continue to do the non-intoxicating hemp on the Missouri side. But I would plead for just common sense legislation here. This is easy to legislate, and if you can manage hemp, if you can do tobacco and liquor, there's no reason that you can't do these. 21 plus ID. The testing is very simple. That's pretty much it. Any questions?
I have a quick question. So the prior witness had kind of talked about congressional intent with respect to the Farm Bill, which it sounds like this particular product, which I'm also not as familiar with, kind of got backdoored in kind of unintentionally through some maybe sloppy drafting at the federal level. You had mentioned that you were involved in some of those discussions. I mean, do you agree with that representation that this was essentially an unintended consequence of Congress?
I would agree with that. Yeah, it was definitely unintended, including myself, right? But just because it was accidental, if you will, doesn't mean that it necessarily ended up bad. The hemp industry eventually will have a large fiber and grain, but without these type of cannabinoids to carry it, I mean, this is the farmers that are growing hemp are barely hanging on now without these type of products, they definitely won't make it to see the fiber and grain industry mature.
Any further questions, Senator Coleman?
Walk me through the existing statutory protections that are in place right now for your products. You say if we put something in that's for over 21 or et cetera, are there any such limitations right now?
There's not, and we would definitely advocate that you place them.
And are those products intoxicating? I know you're calling them unintoxicating, but my understanding is that they do in fact have some sort of a biological reaction that is caused by them. Is that correct?
That is correct. I think it was a misunderstanding. We make non-intoxicating as well as intoxicating cannabinoids.
Okay, and right now, any person at any age is able to buy those in the state of Missouri. Is that correct?
Technically, I don't know of anybody that does that, but
But that would be done on
theoretically,
an
that is
individual
correct.
basis about whether somebody protects them as and.
That is correct.
And are these products protected by any of the marketing limitations that the marijuana industry has about packaging and marketing to children?
No, it is not. I mean, the packaging that we make and the vast majority of the packaging that I see does say 21 plus, is child safety resistant, just like marijuana. It's the same packaging, in fact. I would advocate that you place that in the law, that we alter
So
what
your
we have here.
suggestion is that this entire industry has been developed basically kind of by accident, but it's here now, and that that this proposed limitation is one that you don't support, but you would support creating a whole new regulatory framework and support?
Very much so.
Who's sponsoring that bill?
We
Who have you brought forward to do that?
We have an entire group of Missouri Hemp Association here. Yeah.
Okay. If somebody could
I know
get-
we're capable of doing that.
Interesting. Okay. And do you know what the fiscal note of that would be? Do we have any of that information? I'll ask when he
Okay.
opens up. That's fine. I'm sorry. I'm not trying to catch you.
That's all right.
Are there any states that have put that regulatory framework in place
Quite
that
a
is
few,
separate and apart from the marijuana industry?
There are. Top four off the top of my head would be Minnesota, Kentucky, Tennessee, Florida. They're all pretty similar language. They'll limit milligrams per piece, and some limit how many pieces per container. I would probably Kentucky is the best to look at, but they're all pretty similar.
Okay, thank you.
Senator, okay. Any further questions for the witness? Seeing none.
All right, thank you.
Thank you for your testimony. Next witness in support, and it's just a reminder, since we've heard from the principal witnesses on each side, witness testimony is limited to 2 minutes.
Good afternoon, Mr. Chairman and members of the committee, and thank you for allowing me to be here today in support of SB 984. My name's Julie Weber, and I'm the director of the Missouri Poison Center at SSM Health Cardinal Glennon Children's Hospital, and I'm the immediate past president of America's Poison Center, the association of the 55 poison centers in the U.S. And what I'd like to talk about today is our great concerns about the variety of products out there with the cannabinoids and the effects that we're seeing and the safety issues for not only adults, teens, but especially the children that we've been having cases on. So with this, mastering this ever-increasing, changing, really platform, what we're seeing with the THC. The Missouri Poison Center, I've been there that long, back in 2012, was part of identifying the effects with K2 and the substances and bringing that forth and working with the DEA to get legislation against those products because of the effects. With this, the misapplication of the 2018 Farm Bill has really allowed producers to have no really quality controls, really the content and the milligram amount, it varies. And it's allowing this supply to be in gas stations and head shops where we receive calls that teens are getting into these and buying these products or not even knowing. Also, what we actually see are there's concerns about the composition is really different if there is that on the label. The Poison Center has concerns really about the accessibility, standardization, quality control, as well as adulteration of these products. I can get into the different things, and there's actually a study in my testimony that I'll leave down here. But there is actually regulated and tested products that have been there that they're identified potential sources of problems. Impure CBD feedback, post-reaction purification, and problems in the analytical process that's really saying it's certifying it, but then when it comes down to it and ingested, there is a problem with the purity.
And I'm going to ask you to just wrap up your testimony. We're
Yeah.
at 2 minutes.
So what I'd like to say too about our numbers. So what we've seen in the last year, we've more than doubled from 2021 with over 515 exposures to people, adults, teens, and children. But in children, what we've seen is it's more than doubled every year with exposures to just last year, 205 exposures in children 5 and younger getting into these products. And it's the packaging as well that's a big concern. Attractive, has bright colors, mimics foods, candy. It also has cartoon figures on there. These packages contain sometimes over 1,000 milligrams of a product, and kids are getting into them. They think it's something good to eat and have it.
Thank you, ma'am. Senator Coleman.
Thank you. I appreciate your patience. I just don't know much about this issue, and so I have a lot of questions. Did you say you were a physician?
I'm actually a pharmacist and a
Okay.
certified specialist at the Poison Center.
So trying to understand a little bit about the difference between these and the regulated products, is it the best analogy like the percentage of alcohol? So maybe, you can sell vanilla over the counter, but you have to be 21 to be able to purchase above a certain alcohol threshold for the product. Is that the closest analogy, or are these really identical at a chemical level?
So they're not identical at the chemical level. There's just one carbon atom changes in the molecule, and you get very close to, you have the delta 8, then you can extract it out and get delta 9, that is
And I had a
delta
farmer
11.
explain to me at some point that sometimes when they grow hemp, they don't always know until after they've harvested what percentage of
That is correct.
THC it is, so they don't even always know whether they're able to use it in different ways.
And that is really true, because when they're extracting it out and these terpenes that come out and what they're seeing, it can be a very strong concentrated delta 8 or delta 11. And even Poison Center World, we're having trouble keeping track because there's so many iterations and numbers up to 25, and they can be as intoxicating as delta 9. And we've seen it in children that have gotten into it. I mean, it's a product that they think they're getting a soda, and next thing you have a child that's not able to walk, passed out, trouble breathing. And that's where my concerns come in, is that regulation really needs to be in place to get that quantity and to figure out what is in there, as well as the labeling.
Thank you so much.
Any further questions for the witness? Seeing none, thank you for your
Thank you.
testimony. Next witness in opposition. Sorry.
Mr. Chairman, members of the committee, good afternoon. My name is Ron Leone. I'm the Executive Director for the Missouri Petroleum and Convenience Association, and that means I represent many of the gas stations, convenience stores, and truck stops in your various districts. Now, Mr. Chairman, I know time is tight, so I kind of want to get to the nub of what we support, which we hope is the sweet spot. The companion bill, the House companion bill, was heard last week. So I've had some time to reflect on this over the weekend, and I think our position at that hearing, as well as this hearing, is really where you can find the sweet spot for this burgeoning new market. So our position, Mr. Chairman, is much like the proponents. We support reasonable state regulations, and that includes, of course, selling only to adults 21 and over, testing to ensure safety, potency, compliance with federal law, and any sort of packaging requirements in order to protect children from that. We absolutely support that. Right now, the only tax associated with this product is sales tax. You might want to think about putting on an additional tax. But fundamentally, the nub of the issue you're going to find is that the real question is, where do you sell these products? That's what this comes down to. Everybody agrees with everything else. Everybody agrees with the reasonable regulation, the reasonable taxation. The question is, who do you allow to take advantage of this new and burgeoning market? So we support the broadly authorizing the retail sale of these products in as many retail locations as possible. My stores, other retailers, and the dispensaries. What we don't support about the bill, and again, that's the nub, it is definitely about protecting children, it's definitely about selling to 21 and over, but the key is market share. We don't support the bill in its current form because it unfairly and unnecessarily increases the power of the marijuana monopoly. It interferes with the free market. It picks winners and losers, and it only allows the sale of these products in the marijuana dispensaries. So full regulation, full taxation, but don't increase the power of the marijuana monopoly by only allowing them to sell these products. Happy to answer any questions,
Thank
Mr.
you, Ron,
Chairman.
and thank you for keeping it tight within the time frame. I appreciate that.
You bet.
Any questions for Ron? Senator Coleman.
In the interest of time, do you mind
Good afternoon.
finding me? I'm going to say this for people going forward. If you're in the building, typically, if you'd come find me so that we can talk a little bit more about it, I'd appreciate it.
Absolutely.
Any other questions? Seeing none, thank you for
Thank
your
you.
testimony. Next witness in support.
Good afternoon, Chairman, Committee. Thank you for having me. My name is Dr. Diana Coates. I am a plant biochemist by training. A little bit of a science lesson for everybody. So one of the a great analogy for hemp-derived CBD, hemp, which are in and of themselves non-intoxicating, is the conversion of barley or hops to beer and alcohol. So barley and hops themselves are non-intoxicating. They're not very heavily regulated because of this. But when we induce a chemical change creating alcohol, that is when regulation steps in. We're regulating packaging, age of sale, taxation. When we look at hemp and hemp-derived chemicals, we have hemp, which is on its own non-intoxicating. CBD has been shown to be non-intoxicating, but with some creative chemistry, we can create intoxicating delta 8, which is kind of like, in our alcohol analogy, it's like beer compared to liquor, whereas delta 9 is our liquor. And so delta 9 is intoxicating, and this is the molecule that is kind of the signature in medical marijuana. Now, that conversion happens by taking purified CBD. We mix that with a solvent. Then we add kind of a chemical change agent, so a catalyst to it. That can be either a strong acid or sometimes metals are used. That concoction is heated for usually a long time, 18-ish hours at near boiling, so about 80 degrees C. And then at the end, you're inducing this change from CBD to delta 8 and or delta 9. Now, the end product that we get, we then have to clean that up because that not only has a strong acid or metal in it, but it also has a solvent in it. And so that has to be extracted from that before that product can be safe for consumption.
Thank you for your testimony. And thank you also for that explanation. I, unlike some of my colleagues, did not get an A in chemistry, but that actually made a heck of a lot more sense whenever you explained it just now. The one kind of overarching question that I have, since you're obviously a chemist and a technical expert on the chemical composition between these two different products, can you explain, I mean, you're obviously here testifying in support of this legislation, why you believe that it makes sense to use the regulatory framework that's under the bill as opposed to, for example, let's say the last witness who said that, we should have, two separate regulations governing it. Why should it be one regulatory scheme?
Especially when we consider hemp-derived delta 9 THC, which has made quite a bit of news in the state of Missouri recently. That molecule in it of itself, in effect and in chemical composition, is pretty much the same as the delta 9 THC found in medical marijuana. We have an existing framework that, while not perfect and coming from an operational perspective can be burdensome at times, why reinvent the wheel? Beer and liquor are both under alcohol regulation. And so I think it adds extra burden to the state, in my opinion.
Thank you for that. Any questions for this witness? Seeing none, thank you for your testimony. Next witness in opposition.
Good afternoon. I am Dan Vietz, an attorney. I have practiced law throughout the state of Missouri for 38 years, primarily defending people in marijuana charges. I speak on behalf of the National Organization for the Reform of Marijuana Laws. We've worked for more than 50 years for the interests of cannabis consumers. Like other speakers, we're not opposed at all to reasonable age limits, regulations, certainly testing for potency and purity. What we're opposed to is more prison. And that's what everyone seems to have missed about this bill. This bill calls for aggressive enforcement of the marijuana laws by the Department of Safety and other pertinent law enforcement agencies. They are mandated to actively and aggressively enforce the provisions of this section. Well, one of the things I regret, and I had a seat at the table in the drafting of Article 14, both the medical and the adult use provisions, is that we didn't reduce the penalties for distribution. The penalties are extremely harsh. Those are the penalties that would apply here. The first offense of these tens of thousands of people working in convenience stores across the state would be up to 10 years in prison. The second, up to 15. The third, up to life in prison. The same penalties we impose for heroin, for methamphetamine, and for all the other presently prohibited substances. I think what the voters said is no to prison when they adopted Article 14, both sections 1 and 2. I urge you to look at the fiscal analysis. This is not my conclusion, but the conclusion of the Department of Health and Senior Services, quoted in the fiscal analysis on this bill, says this would place hemp-derived intoxicating cannabinoids under the framework of Article 14. However, under that framework, these substances cannot be created or used. So it is a ban. It is a ban unless DHSS and the Legislative Fiscal Oversight Office are mistaken. It is a ban on the manufacturing and the consumption of these substances. Then they go on to speculate that the fiscal cost to the state is between zero and infinity. That's the precision with which we can estimate the cost. But at over $22,000 a year to imprison people in this state, and judges will imprison people for these offenses, you're making all of these substances that are currently sold openly crimes, really harsh, serious crimes, lots of prison. That's what this bill's about. That's what we're opposed to. I'll be glad to try to answer any questions.
Okay. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chairman, members of the committee, thank you for your time. My name is Anthony David. I'm the owner and COO of Green Precision Analytics, a licensed cannabis testing laboratory in Missouri. In addition to the typical framework of setting up a regulatory body such as rules, application, and licensing, laboratories have to adhere to an even stricter set of standards in Missouri, such as ISO accreditation. Additionally, with testing not being regulated for hemp and cannabis by the FDA, there is no standardized method for testing or sample prep that is given to laboratories, kind of leaving us on an island to develop our own. We have to prove to the ISO accreditation board that there's repeatability and validation in those. So that leads to excessively long timeframes for startups of laboratories. The cost and time associated with this process could potentially lead to a years-long delay for these products to get to market, and when rushed, can severely impact the accuracy and the integrity of the results. All of the laboratories in Missouri have had our difficulties with DCR when it comes to the rule set. We've questioned everything from the contamination limits to the amounts of the samples collected and even the very short time frame for results to be reported. Probably no one more than I. That being said, when you look at the program from a bird's eye view, everything has been in the interest of public safety. After working in 5 different states with 5 different regulatory bodies, I can say without a doubt that Missourians are consuming the safest cannabis in the U.S., if not the world. It kind of befuddles me why we would spend the time and money and completely eliminate fiscal responsibility to carbon copy a program that has been so successful in the realm of public safety. Thank you, and I'm open to answer questions.
Thank you. Thank you for keeping your testimony within the time constraints. Any questions for this witness? Seeing none, thank you for testimony. Next witness in opposition.
Hello, my name is Jade Owens. I am the lead chemist for CBD American Shaman, and I've come here to basically tell what I do for a living. And so it is my job to ensure that we are providing safe consumable products for all of our customers and also have a safe workplace for all of our employees. We want to make sure that everyone is trained and they know what they're working with and that sort of thing. And so in order to have a safe consumable product, we go through a rigorous testing process and honestly a vetting process with whom we receive our active ingredients and inerts from. One of the first things that we end up doing is going through a vendor approval process, and Anthony, who just spoke, he actually went through our vendor approval process for laboratories. There's certain guidelines that must be followed. You must be ISO certified, you must have a website, you must have a QR code, you must have a dashboard. At the time when they were actually opening as a business, when we were going through the vending process, they weren't ISO certified, so we weren't able to actually approve them as a vendor, but later on we were. Once we go through that process, we end up receiving a sample of the material, and we are required that you have to have a full panel analysis or a certificate of analysis that goes with the sample. There's 6 items that we test for. I call them the big 6. It's cannabinoid profile, terpene profile, heavy metals, residual solvents, mycotoxins, and pesticides. I am also on a technical committee for the U.S. Hemp Authority for isomers, so we can try to regulate or self-regulate within our company to make sure that we are offering a safe consumable product. But once we receive that sample, we end up testing it in our laboratory facility in duplicate. We have several different HPLCs, which stands for high pressure liquid chromatography. We test this in duplicate in order to make sure that there's no discrepancies in between instruments. And then we also send it off for a third party to ensure that whatever we're receiving from the vendor matches up with them, it matches up with us, and also matches up with our third party vendor. After that, we go through the batch making process to make sure that we are making a product that is consistent with our label. And then once we test it, if it's consistent with the label or the specifications that we have outlined for that product, we will move on to more of a quality standpoint where they're looking for the right dropper, the right bottle, the right label, the right batch code, the right QR code, the right expiration code, and making sure that this is an accurate product that's being sent out to our stores so that we don't have customer complaints or any type of problems that may allude back to us.
Thank you for your testimony. Any questions for the witness? Senator Coleman.
So I was talking to somebody about this bill that was coming up and how I didn't really know how I was going to vote on it because I'm confused about the subject a little bit. And they suggested that you scan the back of the product like you're talking about to see. And there were a number that were scanned and not one of them came up with any information. They all said unknown for pesticides or unknown for heavy metals. Is that just a freak sample size that was not good, or?
I would consider that's company negligent by whomever you pick that up from. I know when we have ours, it comes with a batch code, and then you go onto our search bar onto our website, and you're able to type that batch code in.
So that's what I was trying to do, right? To go and look, and they couldn't find any information on a number of the different ones that they looked at to try to check this out for me. So, again, totally possible that it's a freak small sample, but we couldn't find any data. Do you know what portion of your company's information does end up having non-specified information about pesticides or heavy metals or whatnot?
I'm in charge of basically giving all of the C of A's that we do receive to another person where they're more of our website IT person, and then they're responsible for putting them all up. And then we also have another person who does an audit of the website once a month, and then they look for some of these outliers to make sure that they are properly uploaded and that our search engine is working towards us.
Okay, thank you.
Yeah, no problem.
Any further questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support?
Darrell Moore, Executive Director for the Missouri Association of Prosecuting Attorneys and the Missouri Office of Prosecution Services. Like the Senator, I took chemistry a long time ago, but I am not here. Do not even, well, you can question me about chemistry, but that was in high school. And you can see how old I am today. The citizens of the state of Missouri saw fit to ensure that marijuana is sold only subject to the regulation and in a licensed dispensary, in part, as the Amendment 3 itself said, to protect public health by ensuring the safety of marijuana and products containing marijuana. Delta 8 and Delta 9 and other intoxicating cannabinoids contain the same active ingredient, intoxicant THC, found in marijuana. In fact, you just heard testimony from an expert that the Delta 9 from hemp is nearly identical for all practical purposes to Delta 9 in marijuana. Therefore, we think it makes sense, as proposed in the Senator's bill, to put it under the same regulatory scheme and distribute it only from the same dispensaries so that you do have, indeed, quality for control. That's why MAPA would strongly encourage this body to adopt the Senator's bill. I'd be glad to answer any non-chemistry questions.
Any non-technical questions for Daryl? Seeing none, thank you for your testimony. Next witness in opposition.
Mr. Chairman, members of the committee, my name is John Geronti. I own Show Me Beverages. We are a craft beer, wine, and spirits distributor and a distributor of products that we're talking about across the entire state of Missouri. I, out of respect for everyone's time, completely agree with Mr. Leone's testimony, and if you have any questions, feel free to ask.
That was the best testimony all day.
Thank you.
Any questions for this witness? Seeing none, thank you for your testimony. Next witness in support.
Try to be brief. I don't know about that brief, but I'll try. My name is Brian Taylor. I am a captain with the Jefferson County Sheriff's Office. I want to share a brief story with you that may touch on some of your points and questions you had, Senator, about some of the age restrictions. I, like most people in this room, I have 3 beautiful kids that I adore. I also have a daughter that when she went to high school, like most high school kids, struggled to make friends. So what do those kids do? They get with the popular kids, they start hanging out and do whatever the popular kids do, which was fine and dandy until I got a call from the school resource officer that said my daughter was found passed out in the bathroom at school. We don't know exactly what she took, but based on the description of the packaging, we tend to believe it was probably one of these unregulated products. Where my frustration came in for law enforcement and as a father is that these products she took, there's nothing illegal about her getting them. Whoever got them, whoever distributed them to her, there was no regulations on them. So for that standpoint, that is why I urge you to support this bill. If you have any questions, I'll be happy to answer them.
Thank you. Any questions for Senator Coleman?
No, just thanks for driving up from Jeffco. I know that drive very well.
You're welcome. Thank you.
Thank you for your testimony. Further witnesses in opposition.
Thank you, Mr. Chairman, members of the committee. Jake Silverman, registered lobbyist for Missouri Smoke Free. We just want to go on the record in opposition to this bill solely for the purpose of vape shops that I represent. This is about 5 to 25% of their store product. So this would be a pretty big detriment to their store and their revenues. So we're all in for reasonable regulations, and I can answer any questions.
Questions for Jake? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support.
Mr. Chairman, members of the committee, Chase Campbell, just going on support for BJC St. Louis Children's Hospital.
Questions for Chase? Seeing none, thank you for your testimony. Further witnesses in opposition.
Sorry. Mr. Chairman, member of the committee, good afternoon. My name is David Palatnik, and I am the president of CBD Kratom, the largest privately owned hemp retailer in the country. We own and operate 60 stores in 5 states. 14 of those stores are in Missouri. We also host our headquarters in St. Louis County, as well as our fulfillment center. Missouri is our company home, and it is my home. I moved to St. Louis 12 years ago from Tel Aviv, Israel, after I finished my military service. And a year later, I opened my first store in East Delmar Loop in St. Louis City. The reason for success is our product have to hit 3 main points. They're safe, legal, and accurately labeled and tested in accordance with our industry standards. Our products are intended for adults only. This is something we require all of our stores, even when there is no legal mandate to do so. We strongly believe these products should not land in the hand of children. Unfortunately, though, not every company has consumer safety and experience in front of mind. For example, a product that name and look just like a bag of Oreo is asking for a kid to eat them. I have a 5 and a 3-year-old, and if they see Oreo, they will eat them. Unfortunately, these few bad actors give the hemp industry a bad name, and the industry is equally disturbed by these practices. As we look at the Missouri session, many hemp store owners, including myself, are worried that the state may ban or otherwise extremely limit these products. 2023 was a tough year to be in business, and looking at the numbers, if some of our products are banned or otherwise not able to be sold at our store, we will have to close all 14 locations in Missouri. That is several hundred individuals in the state that will lose a good paying job and over 100 families that will be affected. That is also an addition of 14 retail vacancies throughout the state, and this is just one company. We hemp store owners, employees, and customers are asking you not to take away the product that we sell responsibly, but to pass common sense regulation for these products. Age limit, labeling requirement, testing requirement are the most important, so the public knows exactly what they're buying and the products stay out of the hands of children. I'll be happy to continue the conversation if there's any question.
Thank you. Any questions for the witness? Thank you for your testimony. Further witnesses in support?
Good afternoon. Eric Walter with Armstrong Teasdale. I'm outside general counsel for the Missouri Cannabis Trade Association. And I speak in support of the ICCA because it is necessary. And everyone seems to agree we need regulation. And, you know, we had a few listed off, but there's no specificity. And I love the question, well, you know, where's the bill? Who's advancing it? Who's come up with the fiscal note for what this entirely redundant regulatory system would be? And why would we have it anyway? You know, the criticism of DHSS is, I don't know, we call it fair or not fair, but the point is, and I've worked in other states, regulators go through a learning curve. When they're regulating a new industry for the first time, there is a process of them becoming familiar with it, having all their people trained up. Now in Missouri, it expanded again last year, so they've tripled the headcount in that department. They are getting better, and we see it in every other state. They get better as they go. This would not make it more burdensome. If you create a new regulatory body, they have to go through the same learning curve. This doesn't call for a ban. There is no monopoly. There's 425 licenses out there right now, and 100 more are going to be issued in the next 15 months. It's not a monopoly. It's just a limited market, which is what the voters voted for. It says in the Constitution, DHSS shall have the authority to limit, and it's concluded in its discretion that a limit would be appropriate, and that is what the voters contemplated. You know, American Shaman Vince Sanders was up here. I appreciate his testimony. I think it was fairly accurate. I would question, though, about the idea of him losing jobs. I am involved with a client who is selling a manufacturing license to a company connected to Mr. Sanders, as I understand it. I guess I can't say that with 100% certainty, but other people who have come up here and said that you're going to put me out of business, they can acquire one of these licenses. They're available. That's a large percentage of my work is transactions involving these. And as I said, there's another round of licenses that are going to be issued. As far as the C-stores and the other places, you say, well, this is now a part of our program. This is a part of our cash flow. It wasn't before. The Poison Control Center started to track Delta 8 in the beginning of 2021. This is a brand new thing. They become addicted to the influx, but if they want to sell it, they can be at a dispensary. We don't let C-stores sell prescription drugs. We're not going to take that from the pharmacy or create a new environment that would allow it. There's a framework in place that should control.
Thank you for your testimony. Any questions for the witness? Senator Coleman.
I have a quick question. You mentioned that this would be regulating under the system and that the voters voted for under Amendment 3, but clearly not, or we wouldn't have the bill, right? This is a whole additional grouping of products, or the bill wouldn't be necessary at all. Isn't that right?
The bill is necessary to address the unintentional loophole that everyone has acknowledged. That was not Congress's intent to create an avenue for intoxicating THC.
No, but that farm bill predated Amendment 3, right?
Yes, but the rise of these products did not. And to be on the ballot in 2022, the framework for the constitutional amendment had to be finished. I mean, the timing was a little unfortunate. We were actually just talking about that earlier today, that if it had been a staggered year or two different, it could have been addressed in the constitutional language.
Thank you.
Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition? Oh, sure.
I'm sorry.
There you go.
Mr. Chair, committee members, I'm going to be brief. I'll leave you guys this. I'm going to kind of go off script to talk about these things. My name is John Grady. I'm a nice traditional Catholic, so I look at this through a lens of faith on a lot of things. My wife and I own a hemp farm, and we also make products, and we also own an organization called 1,000 Ripples that gives away free cannabinoid therapies to veterans and cancer patients free of charge because of the cost of those products here in the industry. One thing I want to point out I'm trying to get through this, so bear with me. I'm a combat veteran, so if I sound loud, I'm sorry. It's not meant that way. I have an aggressive stance sometimes. SB984, they're not telling you. It's going to strip your regulation abilities away. Because what it's going to do is put hemp regulated under the Department of Cannabis regulation, which you guys know you have no purview to regulate because they wrote that into the Constitution and that 39 pages, that the people passed. And I actually take issue because I've been trying to talk to Senator Schroer about this because him and I share the same thing in common. We were both 40 under 40 St. Louis Business Journal class of 2014. I've reached out to him since December. He refuses to talk to me. I've been walking around these halls for 2 years asking for cannabis regulation.
I would just, any disparaging comments towards committee members should not be made.
Sorry, this is what I've had to deal with for these years. So the Constitution tells me my natural right to liberty and enjoyment of my gains in my own industry. And if we look at Section 2 of the Constitution, Section 35 of the Constitution, the Right to Farm Act, all those things that are in place, not to mention the personal property, all these pieces are in place. And the Supreme Court of Missouri is even ruled saying that cannabis industry has no protections in this because they're an illegal entity. We are the hemp industry, and we are protected under Article 35 of the Right to Farm Act because we are a regulated federally licensed industry. If I have to operate and go to the Department of Cannabis regulation, the federal government has told me I will lose my license. They said because they don't support marijuana at all, if we are seen as being involved in the marijuana industry, I lose, and it's right here, my hemp license, we lose this. And as a veteran, that's unfathomable that an illegal industry would do this. And I've been doing this for 2 years, coming up here asking people to work with me. Yeah, I'm a small guy. We're a small farm, and we do stuff where we give away more than we actually sell. But you shouldn't be able to kill me for an industry that's illegal in the federal eyes.
Okay. Thank you for your testimony. Any questions for the witness? Seeing none. Next witness in support.
Good afternoon, Mr. Chairman, committee. My name is Mike Piercy. I am a owner of Heartland Labs, a cannabis manufacturing company in Buffalo, Missouri. We are a small company. We're family owned. We have 12 employees. And to me, this really should boil down to safety. It shouldn't be about money. It should be purely about safety. With the lack of testing for these products and the wide availability to anyone of any age to purchase these in convenience stores should be an overriding factor. Over money, their jobs lost will be recuperated. If there's major concern about the testing regulations, I don't really understand how we can have a separation of testing regulations when the end product produces the same result. I'm a veteran of the U.S. Air Force, Air National Guard. I've never once tried cannabis or THC products. That's all I have to say.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition.
Good afternoon, Chairman and the rest of the committee. My name is Emmett Monslow. I am the owner of Sacred Leaf in Kansas City. I come to you today in opposition to this bill. As somebody who owns a small business and is a minority and a veteran, this is kind of what has created my American dream and given me the opportunity to become wealthy. They talk about in pro that we don't regulate, that it needs to be regulated. I think everybody agrees with that. There has been a lot of self-regulation that has happened in this industry. So like most of us will put 21 on packaging, do lab testing, maybe child safety locks is one of those things too. But Nobody's arguing that point. What this whole thing boils down to is money. You know, who gets to be the winners of this, right? So you have an industry that has basically said that, you know, the hemp industry is clowns, that we don't know what we're doing, and they're trying to make the same thing out of you by trying to deceive this chamber into passing something that will take the power from you to regulate. This needs to be a legislative regulated product. It doesn't need to be done by the Constitution, the Missouri Constitution. They bought and paid for that Constitution, 30 pages of it. But I think that you guys are well enough, capable enough to see that what the true issue is here. That's all I have.
Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chair, members of the committee, thank you very much. I'd go on the record to officially declare the Chiefs a dynasty and rename them from the Kansas City Chiefs to the Missouri Chiefs, if we can get that done. You know, we've heard a lot of testimony, so I've been in emerging businesses in highly regulated industries for 20 years and been a part of a lot of legislation through that at the federal and state level. I've never seen two opposing sides agree on so many things. Never. It just doesn't happen. Usually we're always arguing about the points, but everyone agrees on all these things. With the exception of who should be in charge of it. Well, 71% of Missourians already said they agreed that the DCR should be in charge. You know, the opposing side, they talk a lot about wanting to be regulated, but they could have self-regulated at any point. At any point in time, they could have self-regulated what they're doing, but that would have cut into profits. So it wasn't in their best interest. If you ask anyone that's in the cannabis space, what's the most dangerous and the worst cannabis market in the entire country, is Oklahoma. That's basically what the current Delta 8 market is. It's just like Oklahoma. They opened with no regulation. They opened with no seed-to-sale tracking. They had no way of verifying who was buying the products. That's what we're seeing now. That's all I got to say.
Any questions for the witness? Seeing none, thank you for your testimony. Next witness in opposition.
Good afternoon, Mr. Chairman and members of this committee. My name is Sean Hackman from Chamois, Missouri, just down the river here. I'm a Missouri river bottom farmer, growing corn and soybeans, and owner of Grandpa's Family Farms, growing hemp for fiber and hemp for flour. I'm also the fire chief there, as well as a member of the Osage County Sheriff's Office, water vessel and ATV rescue teams. Along with all these positions, I'm the current president of the Missouri Hemp Trade Association, which brings me here today. With all that, my time is very limited, but being here today is very important. We as an association feel the hemp industry is under attack through proposed legislation that would erase all the hard work that the association, our farmers, processors, and retailers have done since the passage of the 2018 Farm Bill and hemp legalization. This has allowed us to bring hundreds of uses of this plant to benefit thousands of Missourians. Everyone involved with the hemp plant production has went to great lengths to assure all products are natural, safe, and beneficial through the first ever self-regulated industry. Now, we are forced to put into regulation that all levels of the industry are doing already into legislation, not including the seed side or the fiber production side, but inhalants and ingestible products. This is where we need your help as elected officials to keep a very complicated undertaking short. We're in favor of three basic things concerning a big variety of hemp products. 1, age limits to buy and sell. 2, child-resistant packaging. And 3, labeling safety requirements. These three simple regulatory ideas will assure child and consumer safety on the highest possible level. Also, we all strive to protect our children and youth at all costs. Some situations are out of our control. The biggest reason our youth are getting their hands on these products is not from lack of industry regulation, but from irresponsible parents leaving these products in reach of children in their own homes. We're in favor of legislation that will assure product and consumer safety and allow it to be sold as it is successfully now in hundreds of retail locations. As it is proposed by this bill, moving these products to dispensaries is not the answer. These are federally legal hemp products that do not belong exclusively in dispensaries or under the control of a monopolized marijuana industry. I do also agree with Ron's testimony and Vince's testimony, along with all the opposition to this bill. Thank you for your time. Way to go, Chiefs.
Thank you. Thank you for mentioning the Chiefs. Questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 984.
Good afternoon, Tom Robbins from Okan Trade. I just want to, there was a misstatement made a couple witnesses ago that suggested that you, the legislature, have no say in how the program runs, and I would point your attention to 195.805, which was the edible bill that we passed in negotiation with and compromise with Senator Onder. Certainly not a blazing cannabis advocate, but you can see that we were able to work with them, and it also provides the basis for some of the regulatory underpinning that exists now. Mr. Sanders, I appreciated his testimony in particular, especially the question about the Farm Bill, and he seemed to concede that, in fact, the Farm Bill, Congress in its not infinite wisdom, never contemplated that intoxicating THC products would somehow become legal as a result. We have, ample testimony from the congressional record that also confirms what Mr. Sanders has suggested, which is because hemp only has negligible levels of THC, which is the compound which produces the high. The two plants are actually quite different. Legislation only legalizes hemp with a THC concentration of 0.3% or less. Hemp is distinct from marijuana in that it has a minuscule concentration of THC. The FDA, the DEA issued a clarification on August 21st of 2020. The 2018 Farm Bill does not impact the control status of synthetically derived tetrahydrocannabinols. All synthetically derived tetrahydrocannabinols remain Schedule I substances. In addition to the definition, hemp does not automatically exempt any product derived from a hemp plant, regardless of the Delta-9 THC. This all goes to show a certain regulatory intent that would not legalize these products. And so the concern seems to be, and they're very ably represented, and if I were on the other side, I'd be running the same playbook. But we're yet to see an actual framework, a fiscal note associated with it, and frankly, Mr. Sanders' concession that the Farm Bill did not contemplate these products would suggest that the retailers are engaging in the trafficking of Schedule I narcotics. And so I don't think that we'll start pulling items from Walgreens and start putting them in these sorts of retail operations. And so we don't understand why you would do that here.
Thank you. Any questions for Senator Rader?
Thank you. And I was going to ask you, and if Ethan's coming up next, because I didn't want to, sometimes it's easier just to ask lobbyists instead of putting people who have driven all the way up here and talked about your business and gone through everything. But as the end user, what difference am I going to notice if I go in a dispensary and pick up some gummies versus getting one of these things off the shelf in a gas station?
Well, the answer is on the former, you'll know exactly what you're consuming because
No, I mean, how am I? What's the difference in my high?
They're both quite impairing. Full disclosure, Florida has THC caps, and so I decided to go buy some Delta 8 because I didn't feel like the flower was strong enough, and sure enough, it will intoxicate you.
Okay, thank you.
Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition?
Ethan Thampy for the Missouri Hemp Trade Association, American Shaman, Pinnacle Hemp, Hemp Hooray, and basically all the producers, manufacturers, and retailers behind you. And thank you for this opportunity, Mr. Chairman, members of the committee. I'm going to begin by addressing Mr. Robbins' testimony. So he cited a 4-year-old DEA claim, but that has been accompanied by no rule in the Federal Register. It has been accompanied by no scheduling designation from the Attorney General, and federal courts have upheld the legality of these products under the 2018 Farm Bill. I'm here to share a few documents with you. The first document, and we keep going back to congressional intent. Since in the 6 years since the 2018 Farm Bill, Congress has not moved to ban these products or regulate them in other ways. We are currently working with congressional stakeholders on the 2024 Farm Bill. I'm attaching a document, a letter from Pinnacle Hemp to Congressman Burleson, whose committee last year addressed some of these questions and asked for input. We're also sharing an RFI from the U.S. House Committee on Energy and Commerce and U.S. Senate Committee on Health, Education, Labor, and Pensions, who took input and had testimony submitted last year. So the RFI is accompanied by the Hemp Association's response as well. I'm also sharing a position paper with the Missouri Hemp Trades Association's position. So the question keeps coming up, should we create a duplicative regulatory scheme? My contention is the Article 14 regulatory framework created by Amendment 3 is a duplicative system in of itself. It's a duplicative system because it regulates a Schedule I drug in a state. The appropriate way for these products to be regulated is through the FDA. We are currently working in our responses to congressional requests for information have substantiated our support for a regulatory pathway through the FDA as well as the Tax and Trade Bureau with the Bureau of Alcohol, Tobacco, and Firearms and Explosives. So I would also add we have been working with the House committee that heard this bill on a committee substitute. We have that language. We know that there's some additions. The folks from the beverage side want to see this regulated through the three-tier system in the state of Missouri. That's appropriate. As for anything else, the age restrictions, the labeling and packaging and testing mandates, we urge a statutory a statutory framework for that, but it does not need to be duplicative of anything we're not already doing in alcohol and tobacco, and it does not need to be duplicative of anything that the FDA would do as a 50-state interstate regulator for these products once Congress gives us regulatory certainty. Thank you.
Any questions for the witness? Senator Thompson-Raider.
What's the difference in the high?
That depends on the molecule. So Delta 8 is often said to be, a 2/3 as potent. Many consumers find that to be so. It doesn't induce anxiety and paranoia to the extent that Delta 9 does. Many of our consumers use these for opiate relief or opiate exit, as well as pain relief. You have other THC isomers that have slightly different.
So it would just depend on the gummy milligram versus what's in the.
Right. Gotcha. Right. Pharmacologically, they're all entirely the same. One other name I'd throw out there is Dr. Adrienne Wilson Poe, who wrote an article for the Journal from the American Medical Association last December. She did a nationally representative survey showing that an estimated 42 million Americans used a Delta 8 product last year. That's a big number, right? So, we acknowledge the concerns. We want regulation to mitigate or eliminate those concerns, but the size of the current market indicates that this is really a minute concern for the country.
Got it. Thank you.
Any further questions for the witness? Seeing none, thank you for your testimony.
Thank you, Mr. Chairman.
Further witnesses, actually, can I get a show of hands? How many witnesses do we have still in support? Witnesses in support? Okay. How many witnesses in opposition do we still have left? Okay. We're going to cut testimony down to a minute per side. We've now heard from 11 witnesses, 22 witnesses total, for and against, and we're getting to the point of the testimony where there's some overlap, and so in the interest of time, 1 minute per witness going forward. Next witness in support. Thought I saw one hand maybe up. Oh, we'll do that at the end. Any other witnesses in support? Okay, seeing none. Witnesses in opposition.
Hi, I just have some statements to make. My name is Kara Grady. I own a company, Slap Happy Hemp. What I'd like to say is that we're not against regulation. We want as much regulation that's within reason. And I'd like to say a lot of people use hemp because it's way cheaper than going into the dispensaries. If you go into the dispensaries, you're paying a heck of a lot more for the relief. A lot of people use it for medical. Not many, kids use it. Yeah, they're an easy way to get high. But we're trying to regulate that. But I think the reason why people use hemp is because it's so much cheaper. You go into dispensaries, Missouri, since it started here, you go into dispensary, you're paying way, way more than you would if you went to another state. So that's all I'd like to say. Thank you.
Thank you for your testimony. Thank you for keeping it brief. Any questions for this witness? Seeing none, thank you. Further witnesses in opposition?
Senators, my name is Kevin Halderman. I sit on the board of directors for the Hemp Association. I also own Hemp Array. I own a couple stores here locally in Missouri. A lot of people say that this is a mistake, that our industry even exists. The Controlled Substance Act was updated with the 2018 Farm Bill. It made exclusive definitions exempting out all tetrahydrocannabinoids in hemp. That's black and white. That's how our industry started. 2018, again, Missouri piggybacked on back of that. We had industrial hemp exemption also put into that. With the amendment being approved, we have another exemption of hemp being put into marijuana. So we are not marijuana. We are defined as hemp. The federal law allowed each state the ability to regulate our processes. And so what has actually happened is the fiber industrial market of this has been looked at extremely, while the cannabinoid side has been dismissed and become the black scourge of everything. As you can hear, most of the testimonies talk about all of us are on fair with or approve of regulation and stuff like this. The DEA put out a statement to the Georgia Pharmacological Group stating that all hemp-derived cannabinoids meeting these restrictions and guidelines were not Schedule I drugs. A lot of testing analysis has showed that even in Missouri, testing is a process of repeatability, not of accuracy. And that is a countrywide definition of that. You heard testimony already stating that. Just want to reiterate. So people send off products for testing. That testing then is, these companies show repeatability of that. There's no accurate testing. That's a big hurdle, which I believe the chief equity officer is going to have a background on developing new programs with that.
Thank you. Thank you for your testimony.
Okay.
Since we're down to just a minute per witness, any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition? Further witnesses in opposition? Seeing none, witnesses for informational purposes only.
Good afternoon, Mr. Chairman, members of the committee. My name is Shane Rowe. I'm a citizen from Jefferson County, a non-paid lobbyist. I'm here solely because of concerns of the legislation. And to provide a little backstory, there's some of the institutional knowledge that gets lost in this building sometimes. For the past 8 years, while I served up here the last 2 years, I was the chairman of the Public Safety Committee, which actually heard the marijuana bill that was trying to be done the right way through the legislative process. And what we saw in our committee was an attempt to go around and circumvent the legislative body to put in what the industry wanted. And they were there solely to push out a lot of the players, so to speak, and keep from the Oklahoma model, which was the fair trade, or the fair capitalist society trade of it all. Currently, I serve as a firefighter paramedic and a police officer full-time, and what we see a lot of this in this industry is not what's been spoken about. Somebody asked, what's the difference between one's carbon molecule? What's the difference between carbon dioxide and carbon trioxide, which is two very different chemicals. On the federal level, the THC was actually governed by a molecular body. Even in our state constitution, THC is regulated by the definition, the molecular composition of THC. This is off the hemp that has been turned into Delta-8 is molecularly different than marijuana. One of the main concerns that I see with the legislation is it just doesn't provide that clarification as a cannabinoid intoxicant, what level or molecular level and so on. So that's just a brief, in I guess less than a minute, of trying to wrap things up, of seeing where we've come from in this legislative body. We've had hemp since 2018. We've had marijuana for a year, and already they're trying to come back and regulate the hemp industry. So I don't remember seeing them in 2018, and here they are today. So
Thank you, Shane. Thank you for your testimony. Real quick, so you'd mentioned several times when you said you had issues with the bill. I didn't hear you say anything in favor of the bill, but you came up in informational purposes.
information, more of the process of what happened from 2020, 21, 22, and so on.
So you just want the committee generally to know that this issue has been looked at before.
This issue, and when it was brought up, there was never any concern about the regulation of Delta 8 and the hemp industry brought up into that same time frame that we were bringing up recreational marijuana.
Okay. Any questions for Shane? Seeing none? Thank you for your testimony.
Thank you.
Any further witnesses for informational purposes only? Seeing none, that'll conclude the hearing on Senate Bill 984. No further business coming before the committee. I make a motion that we adjourn. Second. It's been seconded. We are adjourned.